Good afternoon, everyone. Today is Wednesday, February the 18th. It's about 12:02 p.m., and this is a meeting of the Election Law Subcommittee of Government, Labor, and Elections Committee. Today, we're considering four bills to pass, to potentially vote on today for the subcommittee to take to the full committee, as well as we're going to hear and discuss three additional bills. So the way we're going to work this is we're going to be doing the voting session first, and that's so that we can make sure we set aside the appropriate amount of time that bumps right up against our committee time for these three bills that we're discussing today. And Camila is going to do me a favor and bring up each bill individually as we talk about them, if we need to talk about them, or I will entertain any motion that the committee feels strongly that they want to bring forward. And so we're going to start with House Bill 260. That is the Fair Campaign Financing Act, the distributions bill. For reminder for everyone, this bill has a very small and very small change to the current process that allows people that are going into public financing for their elections to simply be able to collect on that money on July 1st of the previous year of the election instead of having to wait till January 1st of the election year. Stan, did I get it right?
Yes, sir.
All right. Is there any discussion on this bill? Camila, if you can move down to the second page, that's where the change is so that folks can see it. Simply moving the date from January 1 to July 1. Is there any discussion on the bill?
For what it's worth, I think it makes sense.
Thank you for that. Thank you, Delegate Terrassa. Any other good comments or questions on the bill? Is anybody care to entertain a motion on the bill?
Make a motion to
Second. Oh, sorry.
Motion to approve by Delegate Tomlinson, second by Delegate Terrassa. Thank you both. Is there any final discussion on the bill? All those in favor, please signify by saying aye or raise your hand.
Aye.
Aye.
Any opposed? Please note your opposition now. Any abstentions? Very good. It passes unanimously. We'll send that on to committee. Now moving on to House Bill 263, early voting center bus stops. And so this bill just seeks to create a route by which individuals who take mass transit are able to then have a bus stop at their early voting location. During early voting, it's important to note this only applies to early voting, but it guarantees that our transit system, especially for people in our low-income communities, as well as in senior citizens and other people who need mass transit, they can easily then get access to their polling place at their early voting center. It promises that they will go off by no more than 1/2 a mile, if I remember that is the radius of which it will go off of its normal bus route in order to accomplish getting somebody to their early voting center. And so with that, I'll turn it over for questions. It looks like Delegate Tomlinson, you were up first, and then Delegate Terrassa.
Yeah, I meant to ask this in the bill hearing, and I didn't. For the section you have pulled up right there in front of you, I understand why this says this subsection does not apply to. I understand number one, the commuter bus routes, but why is MTA and WMATA not covered under this, especially with MTA? I mean, having such a major footprint in Baltimore City.
I have a hunch for both, specifically WMATA, but I'll turn it over and I'll ask Mr. Demarinis, could you jump in on that question?
Sure. Those bus routes are just so fixed, and they also received some federal dollars in there as well. They had issues with it, so we exempted those from this bill here and worked exclusively with MACO and making sure that the counties themselves would have enough time to implement this process.
And
the MACO,
I'm sorry.
I thought I was looking at, I don't think I saw that MACO had submitted any testimony.
No, but because it would impact counties, I always work with them.
Okay, so they signed off on it unofficially, I guess.
I don't want to say because we're on a live stream here, but they didn't oppose it.
It's
fine. It's fine. Okay, I'm good.
And I'm correct, Jared. In MTA specific, there's a lot of bus stops that we're talking about that already happen on a fixed route around early voting centers on the MTA track as well. Yeah. Delegate Terrassa, over to you.
Thank you, Mr. Chairman. And in my experience, Mako knows how to weigh in against stuff if they're opposed. So I'm going to assume no news is good news. And I guess they'll tell us if we're wrong. I agree with Delegate Tomlinson. Like, it would be great if those other pieces were in there, but since this is how it's worked out at this point, I'm okay with it as is, but I do wish we'd have that. My understanding of how this works, let me just make sure I understand, is if you've got a bus route that passes by, is it that it passes by or passes within
Within a half a mile.
a half mile, then they have to make a stop at
Right.
I love this. Like, I think this is a great low hanging fruit of how to get people to the polls. I'd like to see us do more, but I support this as it is. And I think it's a great idea.
Thank you, Delegate Terrassa. Is there any other good questions or comments for the committee? Happy to entertain a motion if we feel.
So moved.
All right. Move for approval by Delegate Terrassa. Is there a second? Second by Delegate, forgive me, I didn't see who spoke.
Second.
Thank you, Delegate Klippinger. My apologies.
Hear you.
Any final discussion? Very good. All those in favor, please signify by saying aye or raising your hand.
Aye.
Any opposed, please feel free to voice that opposition. Abstentions? Very good. Passes unanimously. We'll send it on to the committee. House Bill 156, election law affiliating with a party and voting unaffiliated voters. So this bill seeks to kind of thread a very unique needle in trying to make to help unaffiliated voters participate in the primary process. It allows unaffiliated voters to be able to re-register with a major party to be able to vote that party ticket at the polling place. So we do have an amendment onto the bill. The two amendments that we've attached to the bill are to change the effective date from being an emergency bill to making it so that the bill takes effect in 2028. And so that gives our state board time to be able to work around this bill and be able to effectively implement what it's attempting to resolve here, and which will also eliminate the fiscal note that's associated with the bill. And then the second is that we're going to expand it to be able to use at early voting centers and on election day at the polling places. So they'll be able to do both early voting and on election day, they'll be able to re-register and be able to re-register then and register with a party. We had significant discussion in committee. I thought it was really fruitful. Thank you for everybody for participating in that. And with that, I turn it over to Delegate Klippinger for his questions.
My question is why, first of all, if you'd like, I'm happy to move the amendments so that we can have discussion on the amendments to the bill. But I guess my question on to that second amendment is, why is it relevant if, I guess we're leaving the door open for people to change from unaffiliated to a party registration in the general election where it doesn't really matter? Or we're just giving them the opportunity to change their party affiliation in advance of a primary 2 years down the road?
Apologies. If I said general, I meant to say primary. So that was my fault.
Oh, okay. I'm sorry. Yeah, I didn't. Yeah. Okay. So they could do it at an early voting site or on primary election day.
That is correct.
Yeah.
And can we mute Delegate Silverty, please? Thank you. Yes, that is correct. And can I take that motion, Delegate Klippinger, on the amendment, to move the amendment?
Sure.
Great. Can I get a second is there a second for the amendments?
Second.
Great. Discussion on just the amendments. Delegate Terrassa?
All right. Thank you, Mr. Chairman. So right now, can't people register on they can register on election day or no?
Yes.
They can. Yeah, sorry. Thank you, Stan.
Yeah.
Okay, so somebody could register on election day. This is just if you were already registered as an independent and or undeclared, I forget what we call.
Unaffiliated, yes.
Unaffiliated, thank you.
Yeah.
Although, but not any of the other parties.
Right. So let's take a real world example of something that can happen. An 18-year-old goes to register for the first time, says, I'm not really paying much attention to the elections that are going on in the world right now, and I'm just going to register, but I don't want to be affiliated with any party. I'm going to register unaffiliated. They get closer and closer to the election, and they realize that, oh, actually, I have really strong feelings about this election, and I want to participate. My candidate that I really support is in the Democratic Party. And so this gives them the opportunity as we get closer and closer to that election and they start really actively thinking about it to show up at that polling place and say, I feel strong enough about this that actually I want to change my party registration from unaffiliated to Republican, Democrat, and I want to vote their ballot, or any independent party for that matter, if there is a contested third party.
Okay. But not from, if they're independent, if they're libertarian or Green Party or other, they won't be able to do that, right?
That is correct. They cannot. So if you're a registered Republican, you cannot switch to the Democratic Party. If you're a registered Green Party member, you can't switch to the Republican Party, so on and so forth.
All right.
Okay.
Yep.
Okay, thank you.
Thank you. Any other good questions about the amendments? Again, changing the effective date and adding election day affiliation. All right. All those in support, I'm going to call the vote on the amendments. This is just on the amendments. All those in support, please signify by saying aye.
Aye.
Thank you. Any opposed for the record? All right. Any abstentions? Very good.
Move the bill.
Thank you. Moving the bill as amended. Thank you. First by Delegate Klippinger, second by, I could not see who popped up.
Wilson.
Thank you, Delegate Wilson. Any discussion on the bill as amended? Very good. All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Very good. Passes unanimously. We'll send it on to the committee. Final bill for voting, House Bill 333. This bill has been presented and passed the House, I believe at least 1 year. I think it passed unanimously last year. It simply outlines a very specific process for, well, Camila pulls that up, outlines a process for vacancies that the Central Committee must follow in order to go through the appointment process. I did want to take a brief second and highlight that a member has brought forward a concern regarding a section that outlines that a Central Committee member who is up for that appointment for that vacancy, that they should not have to recuse themselves from the final vote, meaning that they would be actually voting on themselves in that Central Committee process. That is a provision in this bill. They have suggested that they're not comfortable with that. I welcome your thoughts on that problem. Delegate Terrassa.
Sorry, I may have missed that. So the bill as it is, the Central Committee member can vote on themselves.
They cannot. Thank you for asking for the clarity.
The bill says they cannot, and in the proposed amendment, they can vote for themselves.
Yeah, the proposed question says we strike that provision and say that the person, essentially saying the person can actively vote for themselves if they're on the Central Committee, which is the current process that they can follow. Delegate Wilson?
I guess I would disagree with the amendment. I don't know if it's an amendment or just an issue. I think that's part of the purpose of this bill. And I think those of us who've been here a while have seen this, repeatedly happen. I think obviously the recusal, if you're now a candidate because you're on the Central Committee, is probably pretty germane to the intent of this bill. So, yeah, I don't know if this is an amendment or just a question, and whoever's not comfortable, God bless them. Is this an amendment or was this just an issue brought up?
No, it's just an issue that was brought up. So
No.
I just wanted to make sure I brought it before. If we choose to move the bill favorable, I wanted to make sure we gave it airtime to discuss.
I think the issue has been heard. I think you've given it proper justice, but I don't agree at all.
Thank you for that, Delegate Wilson. Delegate Klippinger, over to you.
Well, even though Delegate Wilson just tried to keep me from, piling on, I want to pile on. I come from a perspective that I think that when you have only a few people voting for these vacancies, at least under current law as it stands right now, to have one of them be somebody who is on the ballot, I don't think is appropriate at all. So I would strongly support leaving the bill the way it is.
Thank you for that, Delegate Clippinger. Over to Delegate Tomlinson.
Does anybody know how it's set up on the Democratic side? On the Republican side, I know that the state party's bylaws, they allow for members to vote for themselves, and then I believe individual central committees, I think some allow for it, some don't, in their individual county bylaws allow it or don't allow it. But does anybody know on the other side if it's, I think it is fine on your guys' side.
It's very much the same on the Democratic side. It is, the state bylaws allow for them to vote for themselves. Individual jurisdictions can choose to remove that right, but they are allowed to vote for themselves currently.
Okay, so it's exactly the same on both sides. So, but with this amendment, it would be making it very clear that they can vote for themselves.
That they cannot vote for themselves.
The amendment?
No, I'm sorry. I'm sorry. Yes, the amendment would strike the provision out of the bill that says that they cannot vote for themselves, that they have to recuse themselves from the discussion. And so if we struck that provision, then the current status quo would stay.
Okay.
Yeah.
All right. Thanks.
So we don't have an amendment before us effectively now. Is that right?
That is correct. I apologize. I should stop.
I'd move the bill.
Delegate Clippinger moves the bill. Thank you. We jumped the process there. And second from Delegate Wilson. Final discussion from anybody. Delegate Terrassa, is that a legacy hand or did you have another question?
No. Okay. I'm just reading this. Did you say from a discussion? Like in number 2, with it's highlighted there?
Yeah, that was the piece that we were discussing just now. And so again, well,
that was the voting, right?
No, we voted on the bill. So we've actually moved the bill favorable without an amendment. That's currently where we're at in the process.
Yes, but did you say something about this saying you had to refrain from discussion?
I think the bill is, Mr. Chair, correct me if I'm wrong. I think the bill is basically saying that if there is a vote in an election and you're part of that election, that you're not allowed to be in the discussion portion of, when they choose the candidate, when the people actually get there. Not only you recuse yourself from the vote, you would recuse yourself from the discussion about the vote as well. So you don't have any undue influence on the election.
Correct.
Yeah. Let me say this. I 100% agree with Delegate Wilson on that. What I don't necessarily, and maybe I'm just not reading it fast enough, but I didn't see the language about having to recruit. It says administering the process of filling the vacancy, including advertising.
Shall recuse them. It's the first line. So a member of the central committee who has applied to fill the vacancy shall recuse themselves from administering the process or voting on the individual.
Okay, so discussion would be in that one.
Yes. Number one is
I didn't read it that way, but I'm new to election law, so maybe that's why.
Yeah.
As long as that's part of it, I 100% agree with
wonderful
Delegate Wilson on that.
Thank you, Delegate Terrassa. And then very good. With no further comments, all those in favor, please signify by saying aye.
Aye.
All those opposed, please voice your opposition now. Abstentions? Very good. That bill passes unanimously. We'll send it on to the committee. We're now going to move on to House Bill 350, which is Delegate Wims's bill for the Maryland Voting Rights Act of 2026. This is a rather large bill. There's a lot of components to it. I could go through section by section, but I actually think that I'm going to turn it over to Stan so that I can expedite the process a little bit faster here. Stan, if you don't mind going over the major provisions of the bill, I would greatly appreciate it.
Sure. So few major provisions. Basically the heart of the bill is it prohibits a method of election for the governing body of a county or municipal corporation that would result in the dilution or abridgment of the rights of voters who are members of a protected class. And a protected class is a race, color, or language minority group. So the bill also provides for the circumstances under which this prohibition would be triggered. So one of those is that they have to show that there's racially polarized voting, or excuse me, just polarized voting is the defined term. And then it sets out criteria for determining whether there is a violation of the bill, and various factors that have to be looked at. It also sets out factors that wouldn't be considered for determining whether a violation has occurred. Then further down, it authorizes the Attorney General or any other person to bring an action to enforce the bill. And it provides for remedies, the remedies that can be considered. And provides that deference is not provided to a remedy that's proposed by a local government, that the court can consider any remedy offered by a party or other interested parties. And finally, it provides for expedited relief. So as long as the remedy can be implemented before a pending election, then it would be done. And it also provides for court fees, attorney's fees. So basically, if the plaintiffs are able to prove any violation, then they would have their attorney's fees reimbursed. So that is the major provisions of the bill.
Thank you. And I'll mention before I turn it over to Delegate Wilson for questions, we have, you all should have received amendments in your inbox this morning. We do have 2 amendments to the bill. I'm going to say the second one first because the second one informs the first one. So the second one has to do the methods at which the court can remedy the infraction. We found that language to be slightly too broad and could have really deep unintended consequences if the court is given unlimited authority to remedy any situation. So really what we're talking about is solving vote dilution and figuring out how to use either at-large or district voting in order to resolve vote dilution.
Mr. Chairman, is it possible for them to bring up because I don't know what you mean by the Second Amendment. And
sure. It's on the screen here is the amended language.
Thank you.
So we're deleting the line on subsection 2 there, and instead inserting the specific remedies in which a court can resolve that challenge. And so through those 2 new sections there. And then that leads to amendment number 1, which is on page 2 of the bill, which has to do with definitions. And so in order to make sure that it's very crystal clear what those methods to resolve those problems are, we added some clarifying language around definitions to make sure that it's a bit clearer exactly what we're talking about when it comes to amendment number 2. And so with that, Delegate Wilson, I'll turn it over to you first, sir.
Thank you, Mr. Chair. And I guess this question is for Stan. I feel that there are going to be some grave unintended consequences if this bill passes the way I read it. In light of the fact, especially of what may or may not be happening with the Voting Rights Act. So, the protected classes as they're defined now may very well change. And as such, and I've seen it like the way our EEOC is moving forward on a national level, that we will be creating instances and lawsuits where individuals, because of their race, feel that they are not being properly represented, although they're not currently now a protected class. That's the most legal way I could say it. Do you understand, Stan?
I think I understand. Yeah, I think I understand. Perhaps you're referring to the concern that individuals who are not actually members of a racial minority group could claim protection under this legislation.
I believe without a doubt that would be the outcome once we're done with this the Supreme Court's decision. And as such, I think that we are opening up a huge can of worms here. I understand the intent, and I think this is going to have the adverse effect on that intent when we apply the law, as we see the Supreme Court leaning.
Mm-hmm.
And as such, instead of providing protections for what have been classically identified as minorities, we will actually be in a different situation. But tell me if I'm missing something, Stan.
I would just say that actually, and I would defer to perhaps to our expert with LDF to speak to this further, but the Voting Rights Act currently does, our current Federal Voting Rights Act does apply to any racial group, including members who are not minority racial group
Correct.
members. And my understanding is that there actually have been cases brought by non-minority group members. I'm not sure that any have been successful. So that is actually the current state of the Federal Voting Rights Act.
I have no doubt. Like I said, I'm not talking about the current state. I do understand this. I just don't think that that's going to be, as of June, the current state of the Voting Rights Act. And as such, we will be in entirely different territory. And I think that maybe this is a bill for another year once we find out how the Voting Rights Act is actually going to be applied and if it's even what the existence would be, lest we really open ourselves up for especially by, I don't know, this could happen as soon as we pass the bill. Lawsuits that once in conjunction with the Voting Rights Act that would basically have the opposite effect of what we're trying to do here.
Delegate Wilson, and I'm just going to briefly, for a programming note, I appreciate my colleagues who have respected our emails ahead of time that they won't be called on unless they won't speak up unless they're called on. I think it would be a good idea to bring in Adam from LDF just to respond to your concerns and see if they have a position on this question. Adam, if you could, or Delegate Wims, one or the other, can weigh in, that would be great.
I'm happy to. Delegate Wims, did you want to speak to this, or would you prefer if I do?
Yes, because of the time limit, also have Adam could speak on our behalf. Thank you.
Okay. Yes, and thanks for that important question. I would say a couple of things about that. Stan is correct that under current law and because of the interpretation of the Equal Protection Clause, this is a race-neutral law. It is the case that folks would need to be a minority within their jurisdiction to make use of this law as protected class is defined. So it is a one narrowing circumstance. Generally speaking, there could be exceptions to that, but that is the general intent. And then the other piece I would point to is section 15.7-105. And this gives the court the opportunity to bring into their consideration the history and effects of discrimination as further context. And so, one thing that Stan pointed to is the lack of the success of these lawsuits at the federal level, which is due to the fact that you have to show under a totality of circumstance that there is a history of discrimination that is informing the current regime. So this bill, while not making a rigid requirement and wanting to preserve flexibility for plaintiffs, does allow the courts to consider that kind of context and history. And so I think that would inform decisions along these lines. With respect to the other point the delegate made about, the Calais, he's referring to the Louisiana versus Calais case, which my boss argued before the Supreme Court. And as Delegate Wilson points out, could be decided any day now. I do think that respectfully that actually provides a reason to act right now. It is true that the court could upend the federal protections against racial vote dilution and sharply limit them, which would leave Marylanders with few, if any, protections. This bill, as written, especially prior to the proposed amended language, would continue to provide Marylanders protection in the face of an adverse ruling under Calais. And so I would encourage the body to act in this session now, precisely because of the threat of Calais sort of hanging over our heads. I think it's important to fill that breach at this point.
And if I may, Mr. Chair.
Please, Delegate Wilson.
If again, we're all, looking at the Calais case, so if the Supreme Court comes down with what we expect, won't this be in direct violation of what we presume to be their ruling?
Well, so I would say a few things. Obviously, there's a number of ways the Supreme Court could rule in Calais. The number one is that what's a direct issue is Congress's authority to enforce the Federal Voting Rights Act under the Constitution, right? And so that's partially an issue of federalism, right, and the limited powers of Congress. So in a set of their rulings, it actually would not, directly impact this bill at all. If the other way the court might rule is to put limits on how folks can use be conscious of race in the context of districting, right? And also and talk about the federal standard for remedial action under Section 2, which is the Jingles framework, which you're probably familiar with, Delegate Wilson, and sort of make changes to that framework. One of the strengths of this bill is that it actually explicitly departs from that framework. It provides a more flexible benchmark for establishing liability. And so any changes the court makes to the Jingles framework, again, would not have a direct impact on this bill. To the extent that the court does say that, you know, you can't be conscious of race or other restrictions when drawing remedial districts, that is actually, Delegate, the reason why I think the flexibility from the original language in the bill is important going forward, to say that courts could look at other types of remedial action, such as, for example, cumulative voting that's been used in the South before to open up at-large elections. So there's, you know, I think regardless of how the court rules under Calais, this bill could provide Marylanders with robust protections against vote dilution going forward, structured in the best possible way.
And lastly, Mr. Chair, only because the only person I'm really familiar with here is Stan. From what you just heard, sir, and I'm sorry to defer to you, but you know how I do it. Do you have any differing opinion on what the gentleman just said?
No, sir. Actually, I agree pretty much with everything he said.
Okay, because I just wanted, again, I have no problem with the intent of the bill. I just understand as these things are coming down the road, and I've been trapped in this redistricting thing forever. I wanted to make sure that, and God also apologize for not reading the entire bill, because I didn't. I just wanted to make sure that we're not subverting our intent in a way that basically, you know, upends what actually we're trying to do. But if you guys have confidence, I have confidence in you, Stan. So I don't know the rest of y'all that well, but if that's the case, then I'm good.
Delegate Wilson, I'll try to have my feelings not hurt here. No. I really appreciate that that back and forth and that conversation. I think we actually all understand the bill a little bit better when we have those conversations back and forth. So thank you, Adam, for weighing in on the bill. Any other good questions or comments from our committee, our subcommittee?
Mr. Chair, this Delegate Sample Hughes.
Yes.
Not so much a question, but I do appreciate the clarification that has taken place with Adam and Stan providing that level of information. I know, like, even on the Eastern Shore, in particular Federalsburg, they had to utilize some measures to make sure that there was representation, and the same in my district as well. So I think the bill is of the essence. It's necessary to move forward. Thank you.
Thank you for that feedback.
Chair, if I just one more thing, and I apologize because I was actually thinking specifically of Delegate Sample Hughes, and I just wanted, that's exactly what I was trying to frame this without obviously bringing the good delegate into it. The concern of how to ensure that what we've been doing, we can still do. And if you guys are confident with it, like I said, but just for her specific issue, I want to make sure that we're still able to do that. I think the language they're going to come out with is going to be talking about, you know, race neutral and, you know, not being conscious of race in our decision making, which I'm going to pour through the bill because I still don't know. Again, if you guys think it's going to work, I'm down to try. So
thank you. Thank you, Delegate.
Thank you,
both.
Mr. Chair, and thank you, Delegate Wilson. I appreciate you.
All right. Any other good questions, comments on the bill? We're going to be holding this bill. We're going to be taking a look at it and taking a look at these amendments together. And Delegate Wilson, I'd love to work with you on that. And Delegate Sample Hughes as well. Any other final questions on that bill before we move on to the next bill? Very good. We're moving on to HB 565. So this is Delegate Long's bill. So we had the VRA bill. This is a more kind of direct conversation about district voting, in-district voting. So there's a series of jurisdictions across the state that allow for you to vote that you represent a district, but the entire county can vote for you. And so this seeks to codify and update all of those jurisdictions that provide, that allow for single member districts, that allow the entire jurisdiction to then vote on that single member district, and makes it so that if you live within that single member district, you will instead, only the voters within that single member district will be voting to elect that individual. Stan, did I get the provisions correct there?
Yes. Yes, you did.
Okay. Thank you. So just so you know, the jurisdictions are Calvert County, Cecil County, Garrett County, Montgomery County, and Queen Anne's County, and St. Mary's County. And Delegate Wilson, over to you. You're muted, sir.
Was Charles County also mentioned in this?
Charles County was not in the bill.
So, and I don't remember, which is sad to say. So, because I thought when this came out before, this did affect Charles County. This is not the first time this bill has been pushed through. And because it was basically you had to live within the district instead of not at large. Because I know the way our county used to have it, and Stan, I'm going to ask you a question again, is we used to have basically 5 districts and you would vote, everybody in the county would vote for each of the districts. Does Charles County not have that anymore?
That I don't have at my fingertips. Let me see if I can find
And I'm
it.
not trying to put you on the spot. Maybe this is a question offline, only because it sounds like I know it used to affect my district, and which is why I had some opposition to it. I think the good delegate was trying to solve a problem in a specific area, but it was impacting other districts as well. However, I'm not that good of a politician. I may not have been paying attention. We may have changed, and I just didn't know it. And I think Delegate Long, he's online. Maybe he has an answer to that question.
Thank you. So that's the trigger. Delegate Long, you've been called on. Please, if you'd like to weigh in.
Thank you. Yes, Mr. Chair, thank you so much, Delegate Wilson. Yes, because you all have moved from a commission form of government to a code home rule. And this would apply to boards of education and commission forms of government.
We don't have commissioners anymore?
You have code home rules, so you do have commissioners, but it's not categorized under a commission form of government. So for example, when we had the amendment drafted to include commissioners, one of the reasons we could not have Queen Anne's County. Presently, with the bill, when it just said Board of Education, Queen Anne's County was included within it because it was only impacting their Board of Education. But when we expanded the amendment to include commissioner, we had to remove Queen Anne's County because of how they're structured. They're a code home rule. So it's only impacting commission forms of government.
So and that is the local jurisdictions that operate through the state versus having home rule where they're operating independently from the state.
Yes, sir, Mr. Chair. Thank you.
Thank you very much, Delegate Long. So that's actually a nice segue. Delegate Terrassa, I'm going to turn to you for questions and then segue to the amendments.
Okay, thank you, Mr. Chairman. But I think partially it may have been the amendment that I have a question about. I mean, I think why are we listing out counties? Shouldn't this good idea be used wherever that's an issue? And do we need to list counties when we could just say that's how it is in Maryland?
So the home rule, it doesn't apply to the home rule counties. So that's why it's calling out the ones that operate directly through the state.
And why doesn't it apply to the home rule counties?
They have their own process. Stan, I would ask, I think that's just because they have their independent jurisdiction, right?
I can provide a little clarification on that. So it actually would be lawful for the General Assembly to enact a statewide law that made this change for all commission and code home rule counties. You can't do it for charter counties, however, because charter counties have the authority under the state constitution to structure their county council elections however they want. So that's how it would affect the county governing body. But then for
Did you say the under the Constitution? Sorry to interrupt.
Yeah, so the state constitution gives charter home rule counties the authority to structure their county council elections how they choose. So the General Assembly can't legislate that.
Okay.
But you could legislate it for county governing bodies for code home rule and commission counties. And you can actually legislate it for any board of education because those are actually state entities and state offices technically. So you could have an across the board rule for all boards of education if you so chose.
So I guess my follow-up to that, Mr. Chairman, is that my initial thinking, I'm gonna have to go dig into this and look at it again, but my initial thinking is it would make sense to make it as broad as it can be. I understand the issue of the charter counties, but I mean, it's just my 2 cents.
Sure.
Makes sense to make it broader rather than risk missing somebody.
Absolutely. No, that's a very well taken point, Delegate Terrassa. Thank you so much. So there are some amendments to the bill. Forgive me, Delegate Long, I'm going to ask you to come up on this part of it because I have two sets of amendments, and I think the first one was our first attempt at it, and then you came back a second time, so I have a reprint now, and it's a different set of amendments, maybe a smaller set of amendments. So if you could just summarize for us what those amendments are doing.
Yes, sir, Mr. Chair. Thank you again. So amendment number one, the first amendment that we submitted prior to the hearing would be to add anti-racism language, which would require every Board of Education to adopt an anti-racism policy. And that would be administered and enacted by the state superintendent to each local school superintendent. That was the first amendment. The second one was after the hearing, rather, which would expand this from not just boards of education, but to also boards of county commissioners, which would put this in the same position as the bill that passed in 2021. The only difference from that bill and this bill is the anti-racism policy that I had the amendment drafted for, that you all received prior to the bill hearing.
And you said passed in 2021, passed in the House, but
In the
not
House,
in the
not
Senate.
the Senate. Correct.
Got it. Thank you.
Yes.
Thank you for that. Questions on the amendment? We're going to spend just a few minutes and then turn over to our final bill. Okay. I appreciate the good delegate for jumping on with us. This is a good discussion. I think that this bill and our previous bill certainly have some alignment questions that we would love to talk more about. And so we'll continue working on that. And now we'll move on to the final bill for discussion for today, which is House Bill 219. So House Bill 219 is, not to be confusing for everybody, also called the Maryland Voting Rights Act. And this one deals with a different set of subject matter, which is voter intimidation and suppression, brought by our good friend Delegate Smith. Thank you for being on the call. This bill has a lot of components to it. So Stan, again, I hate to put you on the spot, but if you could try to give us some of the high level stuff, and then we'll turn it over for questions. And Delegate Smith is on the call to help provide clarity, and the Legal Defense Fund, Adam with Legal Defense Fund, is on the call as well to help provide any legal clarity to any questions you all might have. Stan, over to you.
Sure. So first major provision has to do with notice of election changes. So there would be a requirement for 15 days of notice. This would apply to both state and local elections. And basically, there would be a sort of a centralized source of information on the state board's website on election changes and election policies being made across the state. There's a provision about there's a provision about interpreting state laws and regulations in favor of the right to vote. So just sort of a rule of interpretation for courts interpreting our laws. There's a provision on voter intimidation. So it would prohibit acts of intimidation, deception, or obstruction that interfere with an individual's right to vote. And that would include things that would impede people from accessing the polls, and such things like that. Then there's a long section about voter suppression, and this is basically about governmental policies that impede that create a disparity in the access to voting between members of a protected class and other members of the electorate. And the bill provides a lot of criteria for determining when that kind of a violation has occurred. It also allows for any person or the Attorney General to bring an action to enjoin in violation of this provision. And it allows for various remedies to be ordered by the court, and that includes things like additional voting hours or days, additional polling locations, things of that nature. And there's also there's more provisions for notice of governmental policies having to do with elections. There's also a process that's set out for if you're going to bring an action under this section, that you provide notice to the local government, and basically it provides them an opportunity to make changes and to negotiate with plaintiffs to try to work something out before it has to go to court. And finally, yes, and those are the main provisions. It also includes provisions about the attorney's fees. And again, if the plaintiffs prevail and get some relief, then their attorney's fees are paid. So that's it.
Thank you very much. I know there's an amendment to the bill, Delegate Smith. We're going to get to that in just a moment, but on the initial bill, Delegate Wilson.
Thank you, Stan. On this one, I just wanted to go back for the enforcement relief. I think Mr. Demarinis is no longer on the call, but is there any immediacy, or does it have and maybe I'm missing it. So is this is just governmental entities, or can this be individuals who are obstructing the right to vote or intimidating during the voting process?
Right. So there's two separate provisions. So the voter suppression provisions are the ones that apply to governments and government officials. So the intimidation and obstruction provisions apply to anyone. And so you could bring an action, and anyone could bring an action against anyone for the intimidation and obstruction provisions. With regard to the suppression provisions, it has to be a protected class that brings the action, and it would be brought against the government.
And I wanted to go back to the intimidation. So what's the immediate action, and who can take it?
Right. So it would be brought, any individual could bring it, and then it could be brought, a court could order relief.
Because I know we had a similar discussion last week about Mr. Demarinis's ability to get involved when there's like actions going on at specific polls. I take it that's not in this bill.
So actually, this actually would allow for private parties to bring actions against individuals who might be obstructing the right to vote or and engaging in deception or intimidation.
So, and we talk about but not through an administrative process, though.
That's right. This would be through the court, and they would be authorized to get damages.
Is there any reason why we've left out administrative sanctions and enforcement?
Yeah, I guess I think probably because that's already provided for under Maryland law. So there's actually, in addition to a criminal prohibition against this kind of intimidating and obstructing conduct, there's actually authority under current law for our Attorney General to bring an action for injunctive relief to stop this kind of thing. And so they have the authority to take immediate action against that.
Thank you.
Thank you so much, Delegate Wilson. We appreciate that great feedback, great question and answer. Aaron Hustings, you're on the call. Did you have any weigh-in from the State Board of Elections?
No, thank you. Just here in case there's anything that that we can help to clarify.
Thank you. Appreciate that, Aaron. Thank you. Other good questions before I turn it over to the good delegates from Baltimore City to go over her amendments? Delegate Smith, I think it's easiest if you explain the rationale behind your amendments for us. We would really appreciate it, and really appreciate you being on the call. I know you're not at 100% today, so thanks.
Thank you. Can you hear me?
We can.
Okay, great. Yeah, so I believe it was just clarifying definitions around the word reckless. Adam might be able to add some more context because I unfortunately had my laptop recharge on me at a time, or update on a time that was inconvenient just now. So I'm
happy to defer to Adam. I know how that goes, Delegate Smith. Thank you so much. Adam, maybe if you could provide some context around the amendments.
Yes. So as I understand it, the amendments that are presently before we would accomplish two things. One would make the list of violations that are in the bill for the intimidation and obstruction and deception illustrative. So as opposed to the entire universe of violations. So that would say, include. And the second piece is the recklessness piece that Delegate Smith highlighted. So we want to make sure that, when you're attempting to prove out a case of deception, especially, we want to make sure that there's a very high standard that you have to meet, which is that someone is acting with reckless disregard for the truth. And that is a little bit different than a knowing and willful standard, which would require the plaintiffs to get inside the head of the person who's acting, which makes it practically very difficult to prove out that claim. So the idea is to embrace a reckless disregard for the truth standard, which is a high standard to meet. Someone would have to be acting in a way that is not just a simple mistake, but that they absolutely should have known the truth. So the classic examples here are vote on Wednesday, right? Or, that everyone knows the election is on Tuesday. Someone is saying vote on Wednesday for the purpose of deceiving someone and interrupting their ability to effectuate their vote.
So it's important to point out, Adam, that what you're saying is that they also have to know that what they're saying is untrue in the process, because they can't, like, somebody might just been mistakenly speaking and said the election's on Wednesday, honestly just making an honest mistake. It's not going to get wrapped up in a court case like this, right?
Well, it would have to be that you wouldn't have to prove that they in fact had their knowledge in their head. What you have to prove is that the truth was so available to them, right, that to say it was on Wednesday was a reckless thing to say, right? It's not just that they made a simple mistake, but that they crossed the line to being reckless with the truth. So it's attempting to say that you don't have to technically get inside the person's head, because that's almost impossible to prove, but you have a circumstance in which no reasonable person would be able to argue that the election is on Wednesday. They went and created a whole program telling people it's on Wednesday. They must have known or should have known that it's on Tuesday. That's what that standard. Yeah.
So Delegate Wilson, over to you. We've got a few minutes left here.
I apologize, and this isn't on the amendment, this is on the bill itself. And so does this bill at all assist us if, let's say, ICE starts showing up at our polls? And does this have any effect, any ability to protect individuals if, law enforcement, we use ICE or federal agents are, armed standing around our polls?
Who would you like to direct that question to, sir?
Whoever has the answer.
Adam, I think you might be the best position.
Sure. Unfortunately, I have a less than satisfying answer for you, Delegate, which is it depends. It might, right? Which is that there are complicated issues of federal preemption, et cetera. So to the extent that folks within ICE are acting outside their constitutionally authorized duties, and there's a mechanism for holding them accountable on state law, it's possible that this would help. It's very fact dependent, so I don't want to make any promises about how this could be used, but it might.
And I'll admit that, is there any language that in your expertise would provide any additional assistance? Because I do understand, acting within their legal federal authority versus they happen to coincidentally be going around specific polls en masse, with not doing any actions. Or do you believe that this, to the best of its ability, that this bill as drafted can protect us as best as possible from that?
Yeah, I think that this bill, as in terms of the four corners of protections of this bill, there might be other things, separate areas of law, right, that Maryland can do in terms of law enforcement of the polls and things like that, and providing causes of action. But with respect to the content of this bill, which is about intimidation, and what they'd be doing, I think this language is what we would need, if you were able to use avenues to hold federal officials accountable. Yeah.
And to go one more time, so if we have ICE coming to the polls, checking people's identification to prove that they are citizens, you believe, to the best of our ability, this would at least give us some possible recourse?
Yes, this would provide a potential avenue for recourse, understanding that it would, there's all kinds of complications about federal and state law interaction and all that kind of stuff. Yep.
Okay, thank you.
Awesome.
Thank you so much for that. And committee members, I'm going to go ahead and pause the conversation there. Listen, we have tackled 3 huge discussions on ballot access today, and I just want to thank everyone because you all really did it in a timely and efficient manner. So we have a committee meeting at 1 o'clock, so I'm going to pause the conversation and thank everyone for being on the call. We're going to continue our work on these 3 bills together and hopefully come to some resolutions here. So thank you all, and look forward to seeing you in our committee meeting.